welcome to the Deep Dive. Today we're cracking open a really significant piece of South African law, the Legal Practice Act, or LPA, from 2014.
Absolutely. It's foundational stuff. This act didn't just tweak things, it reshaped the entire legal profession.
Right. And it dictates not just who gets to be a lawyer, but also, crucially, how justice is accessed by the public. It's complex, but vital.
It is. And worth noting, it was signed into law in 2014, but the actual rollout that was phased, most of the big changes only really kicked in around November 2018.
That long rollout really tells you something, doesn't it? It's just a major overhaul, not just minor adjustments.
Exactly. So our goal today is to unpack it. What was its purpose? What's this new structure it created? And maybe most importantly, what does it actually mean in the real world? For lawyers and for you, the public.
We want to make it clear whether you're maybe a law student needing the structural basics or just someone interested in how legal services are supposed to work fairly.
Precisely. Let's start with the why. Why did South Africa need this act? What was the problem it was trying to solve?
The preamble gives us some big clues. It talks about historical fragmentation.
That's the key. Before the LPA, you had different laws, different bodies running the show in different provinces, a real patchwork quilt.
And the results of that patchwork? Was it just inefficiency?
It was more than that. The act itself is pretty blunt. It says the profession wasn't broadly representative of South Africa's demographics.
Okay, so a transformation issue.
Major one. And it linked this to constitutional values. The idea was to create a legislative framework to really transform and restructure the profession in line with the Constitution, the rule of law.
So social goals were baked in from the start.
Absolutely. Explicitly. The act aimed to tackle, three big societal failings.
Which were?
1, that lack of demographic representation we mentioned. 2, what it calls unnecessary or artificial barriers stopping people from entering the profession.
And the third?
Access. Or rather, the lack of it. The act acknowledges that for most South Africans, getting legal help just wasn't a reality. A pipe dream, really.
Why? Was it mainly cost?
Cost was huge. The act specifically mentions fees being unattainable for most people. That's pretty direct language.
So the act sets out these goals, transformation, access, but then hits this massive wall, legal fees. How did it try to bridge that gap?
Well, that's where it gets interesting and maybe a bit tricky. It gave the new regulatory body a mandate.
The LPC.
Yes, the Legal Practice Council. We'll get into that more. But it tasked the LPC with ensuring fees charged are reasonable and promote access.
But did it set fee scales? Or tell lawyers what they could charge?
Not directly, no. It sort of punted the really hard structural fix. It mandated the South African Law Reform Commission to investigate this whole issue of high fees and find a permanent solution.
So the act identified the problem, mandated someone else to find the solution. That investigation is still ongoing, isn't it?
It highlights the difficulty, right? Regulating professional fees is always contentious. The act built the structure but left that core economic challenge somewhat unresolved at the point of implementation.
Okay, let's talk about that structure then. The solution to fragmentation was this unified body, the South African Legal Practice Council, the LPC.
Correct. Chapter 2 establishes the LPC. It's a single national body, a body corporate.
And it replaced the old system.
Completely. Section 97 is clear. The old provincial law societies, the bar councils, they were abolished when the main parts of the act commenced. This was a fundamental shift from regional self-governance to national statutory regulation.
A big power shift. Consolidation makes sense for efficiency, maybe standardization. But how is the LPC structured to ensure it serves the public interest, not just the lawyers it regulates?
That's addressed in its composition, Section 7. It's designed not to be pure self-regulation by lawyers.
How so?
Well, yes, legal practitioners, attorneys, and advocates make up the majority, 16 out of the 25 or so members. 10 attorneys, 6 advocates.
Okay, still sounds lawyer-heavy.
But crucially, it also includes others. 2 law teachers, 1 dean, 1 other academic. Very importantly, 3 fit and proper persons appointed by the minister.
And these 3 are not lawyers.
Explicitly not lawyers, and not public servants either. They're meant to represent the broader public interest directly on the council.
Interesting. Anyone else?
Yes. 1 person from Legal Aid South Africa, vital for the access mandate, and 1 from the board of the Fidelity Fund, which protects client money.
So it's a real mix, designed, it seems, to dilute that traditional self-governance and bake in public accountability right into the council's DNA.
That's the intention. And it's reflected in the LPC's stated objects in Section 5.
What are those key objects?
Things like facilitating a transformed, accountable, efficient, independent profession, setting and maintaining professional standards, ethical conduct, the usual regulatory stuff.
But also,
Also, specifically, ensuring fees are reasonable and promoting access to legal services. That public interest mandate is written right there.
so the LPC is the new single gatekeeper, exercising jurisdiction over all legal practitioners and candidate practitioners, but with this strong constitutional and public service directive.
Exactly. Now, let's pivot slightly. Chapter 3 talks about regulating the practitioners themselves. How do you actually become and be a legal practitioner under this act?
Right, the practicalities. What does it take to get admitted now?
Well, the academic foundation is still the LLB degree, the 4 or 5-year version, or a recognized foreign equivalent confirmed by SAQA. That's Section 26.
Okay, standard enough, but the Act added more, didn't it? Beyond just the degree.
Oh, yes. This is where some of the bigger practical changes for aspiring lawyers come in. It's not just about articles or pupillage in an exam anymore.
What's new?
Section 26 mandates practical vocational training, yes, and passing a competency-based exam or assessment, standardized now, but the big one.
The community service.
The community service requirement, Section 26, 1CI, this is mandatory. It's a key part of that transformation and access agenda.
How does that work in practice? What kind of service are we talking about?
The specifics are determined by the minister, according to Section 29. But the Act gives examples. It could be service in the state, perhaps at the Human Rights Commission, maybe even pro bono work as a judicial officer in places like the small claims courts.
Wow. So it forces new entrants to directly confront the access to justice problem.
That seems to be the clear goal. Get them engaged with the system's shortcomings, the public need, right from the start of their careers.
Okay, so you get through your degree, your practical training, your assessment, your community service, you're admitted. How does the Act regulate how you can actually practice the forms of practice?
Section 34 covers this. For attorneys, the core right remains. They can take instructions directly from the public.
No change there. What about advocates? Historically, they needed an attorney to brief them, right? The referral rule.
That's the big shift. Advocates now have options under Section 34(2). They can still practice the traditional way, getting briefs from attorneys, or they can take instructions directly from the public or from a justice center.
Okay, so the referral rule isn't absolute anymore. But there's a catch if they go direct, isn't there? Something about money.
A very important catch, tied to client protection. If an advocate takes instructions directly from the public, they're likely going to handle client funds. Trust money.
And that triggers?
That triggers Section 34(2)(b). They must get a Fidelity Fund certificate, just like an attorney who handles trust money. They have to comply with all the trust account provisions in Section 86.
So the rule is logical. If you hold client money in trust, you need the insurance, the regulation, the oversight that comes with the Fidelity Fund.
Precisely. It aligns the regulation with the risk profile. Direct public access means direct financial responsibility and the corresponding safety net.
Makes sense. The Act also mentions other forms, like attorneys in commercial juristic entities or law clinics.
Yes, it provides for various structures reflecting modern practice realities. But that attorney-advocate distinction, especially around direct access in the Fidelity Fund, is a key regulatory point.
Okay, so we have the structure, LPC, the entry requirements, training, community service, the practice rules, direct access caveats. What about keeping everyone honest? Accountability.
Right. Chapters 4, 5, 6, and 7 really beef up the accountability mechanisms.
Let's start with Chapter 4, discipline.
First big thing. A single, unified code of conduct mandated by Section 36. This replaces all the old, potentially differing codes of the previous bodies. One standard for everyone.
And the disciplinary process itself.
It's structured, layered. Section 37 sets up investigating committees, then disciplinary committers, and then appeal tribunals within the LPC structure.
What about transparency? Old disciplinary hearings were often behind closed doors, weren't they?
That's a key change. Section 38(4) states that disciplinary hearings are, as a general rule, open to the public, much greater visibility.
Okay, so internal discipline is strengthened and made more transparent. But what if you, as a member of the public, feel the LPC itself isn't handling your complaint properly?
That's where Chapter 5 comes in, the Legal Services Ombud, a completely new office created by this act.
The Ombud. What's their purpose?
Section 46 says it's to protect the public interest and ensure the investigation of complaints against practitioners is fair, efficient, and promotes high standards. Essentially, they oversee the LPC's handling of complaints.
And who is the Ombud? How are they kept independent?
Independence is critical. Section 47 mandates the president appoints the ombud. And the qualification, it has to be a judge who has been discharged from active service.
A former judge. That sends a strong signal about authority and impartiality.
Exactly. Their job under Section 48 is to investigate complaints about the LPC's conduct, things like alleged maladministration, abuse of power, serious misconduct, or maybe just undue delay in dealing with the complaint you filed. They're the check on the regulator.
Got it. So strength and discipline plus an independent ombud. What about the money side? Protecting clients financially.
That brings us back to the Fidelity Fund. Chapters 6 and 7 deal with this. The old Attorney's Fidelity Fund continues, but it's now the Legal Practitioners Fidelity Fund.
Same core purpose.
Yes. Section 55 is clear. It's there to reimburse the public clients for pecuniary loss they suffer because of theft of money or property entrusted to a legal practice that operates a trust account.
Theft by the practitioner or their staff?
Theft committed by a trust account practice? Yes. It's the ultimate financial safety net for client funds held in trust.
And we already established that any practitioner holding trust funds attorneys or advocates taking direct instructions must have that Fidelity Fund certificate and follow strict rules for trust accounts under Section 86.
Correct. The Act is very clear that trust money isn't part of the lawyer's assets. It can't be touched by their creditors if they go bankrupt. It's protected. The fund ensures that protection has teeth.
Okay, it's a lot to take in. The LPC, new training, community service, new practice rules, discipline, the ombud, the fund. If we boil it all down, what's the big picture takeaway from the LPA 2014? What does it all mean?
I think the central message is one of necessary, if complex, consolidation and modernization. It moves South Africa from that fragmented, largely self-regulating system
Run by the old law societies.
to a single national statutory regulator, the LPC, with an explicit, unavoidable mandate driven by the Constitution. Transformation, public accountability, and improving access to justice.
So the architecture for a more modern, accountable profession is definitely there. Standardized rules, clearer pathways, stronger oversight.
A framework is in place, yes.
And it feels like there's always a but with access to justice. We keep coming back to the cost.
That remains the fundamental challenge. The LPA did introduce some transparency measures. Section 35(7), for instance, requires practitioners give you, the client, a written notice upfront estimating costs and explaining your right to negotiate. That's helpful.
But it didn't solve the underlying problem of fees being, as the Act itself said, unattainable for most people.
No. And as we mentioned, that huge task was formally handed over to the SA Law Reform Commission under Section 35(4). They were mandated years ago to investigate and find that permanent solution.
So the provocative thought for you, the listener, might be this. We have this reform structure, the LPC, the ombud, all aimed at accountability and access. But can that structure truly deliver access to justice for everyone?
If the fundamental price barrier remains so high, how effective can regulation be if the service itself is financially out of reach for the majority? That's the question that lingers. Watching how or if those Law Reform Commission recommendations on fees get implemented, that's the real test of the LPA's ultimate success in transforming access.
A crucial point, and definitely something to keep an eye on. We really hope this deep dive has given you the clarity you needed on the Legal Practice Act.
It's a landmark piece of legislation, and understanding its aims and structures is key. Until next time, keep digging.